Thank you. So, sir, just to start off, these closing submissions should be read together with the River Oak opening submissions, and they are relied upon in full, but obviously not repeated. And so then, just for ease of reference, we've just set out there the abbreviations that we've used during the closing submissions. Obviously, I'm not going to read those out, but hopefully, again, that's just for brevity in them. So, can I just first of all turn to the first point, and that is the application of Section 38, subsection 6, policy EC4 and the reasonable prospect test. And so the appellant's opening submission mischaracterised the principal issue on which your decision, sir, and the appeals turn. The appellant suggested that the inquiry concerns whether the future of the site is likely to be prejudiced if 4 of the existing buildings on the site are allowed to be reused for commercial purposes pending those wider decisions. In its determined focus on prejudice to the site's overall future, that submission seeks to circumnavigate the relevant policies of the statutory framework per Section 38, subsection 6, which the decision maker is simply not entitled to do. As noted in our opening submissions, the decision must be in accordance with the development plan unless material considerations indicate otherwise. And that was confirmed by Ms. Shembry in her evidence in chief, and also by Mr. Alston in his examination in chief and cross-examination. It's therefore agreed, as indeed it must be, that the determination must be in accordance with the development plan, which is the Thanet local plan, and that the main relevant policy for these appeals, for the purposes of Section 38, subsection 6, is policy EC4, unless material considerations indicate otherwise. And therefore the starting point is policy EC4 and the weight to be ascribed to it. Policy EC4, that's the first one, is concerned with land designated as an airside development area. This area is identified on the local plan proposals map and relates to all the land to the north of the runway and includes the land that the 4 buildings, the subject of these appeals, is located on. This land is specifically reserved for airside development, which is defined in paragraphs 2.74 of the local plan as uses with an operational requirement for direct access to aircraft and therefore dependent on a location immediately adjacent to the runway or capable of direct access to it via taxiways. It was agreed by Mr. Alston that this policy applies to both temporary and permanent changes of use and whether or not the airport is operational, and that its purpose is to protect the integrity of the airport as an airport. It is agreed that these proposals are contrary to policy EC4, and therefore, in accordance with Section 38, subsection 6, permission should be refused for these proposals unless there are material considerations that indicate otherwise. There is a dispute over the weight that should be applied to policy EC4. Mr. Alston suggests that some weight should be applied, whereas Ms. Shembry suggests that full or significant weight should apply to the policy. It is submitted that the case for applying full weight to policy EC4 is convincing, unlike Mr. Alston's position, which is not. Mr. Alston agreed that the weight to apply to policy EC4 is the degree to which it is consistent with the NPPF. He agreed that there was nothing inconsistent in the NPPF with a policy that seeks to protect an airport as an airport. Policy EC4 is therefore consistent with the NPPF. Mr. Alston also agreed that the national policy on aviation contained in the Aviation Policy Framework recognises the critical role that airports play in benefiting the national economy, seeks to ensure that the UK remains one of the best connected countries in the world, seeks to ensure that better use is made of what airport facilities the UK has, including their existing capacity, and recognises the importance of the role of regional airports. and therefore policy EC4 in seeking to protect Manston Airport as an airport is wholly consistent with both the NPPF and national policy, which regards airports as strategically significant assets, and that was not contested. River Oak contend that whether EC4 attracts full weight depends upon whether or not there is a reasonable prospect that the airport will be used for the purposes for which it was intended. Whilst Mr Alston accepted that his original justification for the grant of planning permission for these proposals and his evidence to this inquiry were both predicated on that basis, he sought to row back from that position in his examination in chief. His evidence, I suggest, was muddled and confused on this. He seemed to accept... Sorry, yes? Thank you. His evidence was muddled and confused on this. He seemed to accept that the issue of a reasonable prospect was relevant, but not a key issue, and not a matter upon which you, sir, needed to reach a view. We submit that ultimately he accepted that it was relevant, was a key issue, and you, sir, do need to reach a view on it. Even if he did not, it's submitted that that is the correct approach. We submit that at times Mr Alston appeared to be confusing the two concepts of whether there is a reasonable prospect that the airport will be put back into airport use and whether it can be conclusively stated that it will. The first concept is relevant to this appeal, the second is not. However, we suggest that it is telling that the appellants appear to draw away from the reasonable prospect test. We suggest that this is because it is incontrovertible on the evidence before this inquiry that the test is satisfied. We submit that the satisfaction of this test is not whether it is certain that the use will reactivate, nor whether it is likely that it will, only that there is a reasonable prospect that it will, namely a prospect that it is not frivolous or theoretical. A possibility that it will is sufficient. That there is such a possibility was conceded in the appellant's opening submissions. The reasonable prospect test emanates from the National Planning Policy Framework. Policy 22 states, planning policy should avoid the long-term protection of sites allocated for employment use, where there is no reasonable prospect of a site being used for that purpose. Land allocations should be regularly reviewed. Where there is no reasonable prospect of a site being used for the allocated employment use, applications for alternative uses of land or buildings should be treated on their merits. Mr Alston accepted that the policy of protection in this case, namely EC4, is for a specific employment use, namely aviation use, and therefore any change of use to general B1, B and C or B2 and B8 uses would constitute an alternative use for the purposes of this policy. He did not seek to defend any position that paragraph 22 did not apply. This was a change to his evidence in chief, where he sought to suggest for the first time that EC4 is somehow not an allocation of land for the purposes of paragraph 22. This is clearly untenable. The land is reserved as an airside development area for airport use and shown as allocated as such in the proposal's map. The reservation of land for a particular use is the same as its allocation for that use. Any suggestion that it is otherwise is unarguable. It is therefore appropriate and necessary to consider whether there is a prospect which is real rather than frivolous that the airport may be used as an airport. It is submitted that it is untenable to suggest that there is not. It is also important to note that the reasonable prospect test is predicated upon the basis that the use or allocation is not currently operational or taking place, but is the subject to a policy of protection which is precisely the situation here. Otherwise, if the use is operational, it serves no useful purpose. The points relied upon, therefore, by Mr Alston in seeking to demonstrate that the reasonable prospect test is not satisfied need to be seen in that context. On proper analysis, none of these points demonstrate that the reasonable prospect test is not satisfied, and they are addressed below. The fact that the airport is closed and vacant and has no aerodrome licence merely reflects the circumstances that give rise to the application of the test in paragraph 22, which is concerned with policy protection of allocated land that is either vacant or not in use for the purpose for which it is allocated. It is not therefore possible for these reasons to be relevant as to whether the test is satisfied, as they are merely the circumstances that give rise to the test to start with. Mr. Alston accepted that, but then sought to suggest that they are nonetheless relevant. Again, we suggest his evidence was inconsistent and confused on that point. Moreover, in any event, it is quite clear that the closure of the airport and the stripping of its aviation equipment does not demonstrate that there is a reasonable prospect that it will not be used as an airport in the future. Manston Skyport purchased the airport in 2013, stating that it represented a real potential for growth that has not been fully captured, and that the then owner was well placed to help maximise opportunities for both freight and passengers at Manston. However, only after 4 months the airport was closed and then subsequently sold to another development company in which Anglo has an interest to develop the land for housing. No evidence has ever been put in the public domain, and certainly not presented to this inquiry, to demonstrate that a financial appraisal was undertaken which showed that the airport was unviable or could not be made viable at the time it was closed. If such evidence exists, it's extremely surprising that it has never been produced. Mr. Alston accepted, in cross-examination, that his suggestions that the airport was not viable or could not be made viable at the time of its closure are merely unevidenced assertions. Those assertions are directly contradicted by the unchallenged substantive evidence of 3 experts at this inquiry that the airport can be made to be successful, which is wholly consistent with Mrs. Gloag's statement at the time she purchased it. It is quite clear that the reasonable prospect test is satisfied. Moreover, the fact that the owner has no intention of selling the site is neither here nor there. As Mr. Alston quite rightly accepted, the planning system is not there to serve private interests or aspirations, and compulsory purchase powers exist to get around an unwilling seller. The planning system does not allow the truculence of owners to dictate how land should be used, and no weight can be ascribed to that intention. In addition, Mr. Alston accepted that his reliance on the fact that 2 previous owners had not managed to make a success of the airport did not include any analysis or explanation of the specific reasons as to why those owners had failed, nor any analysis of the specific reasons for that failure or whether they need to be repeated. This is in stark contrast to Riverig's unchallenged evidence that there were specific reasons why past owners had failed and that those reasons need not be repeated in the future. In light of this, no weight can be ascribed to the past failures of previous owners in considering whether there is a reasonable prospect that the airport can return to airport use. In addition, the suggestion that there had been a material change in the use of the airport as a result of a special development order known as Operation Stack to address the problems of queuing lorries seeking access across the channel does not mean that there is any reason or impediment to the airport being put back into airport use. The airport has never been needed to be used for the stationing of lorries upon it under the special development order, and that order is a temporary permission which in any event expires in December 2017, and a permanent solution for the stationing of lorries in the event of problems with either the Port of Dover or the Channel Tunnel is now being provided in Stamford in Kent, which should be ready in the summer. Mr. Alston also suggested that there was a significant bank of evidence that demonstrated that there was no reasonable prospect of the airport being used as an airport. He pointed to the fact that the site had been purchased for £1, but had totally failed to appreciate that River Oak had made 4 offers to purchase the site. 3 offers in 2014, which culminated in the full asking price of £7 million, and a further offer in 2016 of £10 million. His lack of awareness of these offers is extraordinary, given that they were made to his client and were referred to and produced in Mr. Yarrell's evidence. Moreover, Mr. Alston's reference to the airport's commission report and his assertion that it had indicated no strategic need for an airport at Manston was only a partial reference. The full reference in the report makes it clear that the Commission recognised that Manston provides some potential as a reliever airport to free up capacity and more congested airports, therefore, so that should be at more congested airports, thereby reducing the need for more runways. And that is wholly consistent with the unchallenged evidence of Mr. Kane, Dr. Dixon and Mr. Yarrell. In addition, Mr. Alston's reliance on the fact that Thanet District Council did not enter into an indemnity partnership agreement was not based on any understanding of the terms of the indemnity agreement that was on offer, or whether what was being proposed to River Oak was reasonable, as he readily accepted. As a result, and as he indicated, he was not therefore in a position to answer any questions upon his reference to this in his evidence. It is clear from Mr. Yarrell's evidence that the indemnity agreement on offer provided total protection to Thanet District Council against all financial liability, and that what was being proposed at that stage was reasonable given the guidance. There was no requirement or need for River Oak to be able to demonstrate that the funding for the whole project, which is £300 million, was in place at that time. That is all set out in the notes provided by River Oak's solicitors to Thanet District Council. As Mr. Yarrell explained, he could not understand why Thanet District Council declined to enter into the CPO, as the advice that they had received was that, and that's they, River Oak, just to be clear, that the advice that River Oak had received was that all reasonable requirements necessary at that stage had been met. In any event, as the nature of the project is an NSIP, it needs to be promoted via a DCO, so a decision by Thanet District Council not to enter into the CPO is neither here nor there. It certainly does not show that there is no reasonable prospect of the airport being used as an airport. Mr. Alston also points to the AVS Solutions report to show that there is no reasonable prospect of the airport returning to airport use. This is untenable. River Oak called two aviation experts, Mr. Kane and Dr. Dixon. They explained why Manston Airport can be reopened and rendered viable. Mr. Kane also explained why the AVS Solutions report is fundamentally flawed and cannot and should not be relied upon. Dr. Dixon also explained why this was so and concluded that no weight should be attached to it. Neither Mr. Kane's nor Dr. Dixon's evidence was challenged. No expert has come forward to support this report, not AVS Solutions themselves or any other expert. And therefore the position at this inquiry is that the evidence that the AVS Solutions report is fundamentally flawed and cannot be relied upon is unchallenged. That is the position at this inquiry, and any decision on these appeals must be reached on the basis of that unchallenged evidence. Whilst that poses extreme difficulties for the appellant in making their case at this inquiry, it is one of their own making. They are and have always sought to rely on the fact that there is no reasonable prospect of the airport reopening in making their case for the change of use applied for. By making these applications and these appeals, they have put that matter in issue. Moreover, whether there is a reasonable prospect of the airport reopening is the way that the local planning authority, Thanet District Council, have approached these proposed changes of use, both in its consideration at the application stage and in originally seeking to defend these appeals, and then in deciding not to do so in light of the AVS Solutions report. It is wholly unreasonable and untenable for the appellants to then suggest that whilst they have not challenged River Oak's evidence on this issue, they do not accept it. The whole purpose of the inquiry system is the giving and testing of evidence. The appellants have failed to do so on a main point that they themselves rely upon in favour of their own appeals, namely whether there is a reasonable prospect that the airport will reopen. They must live with the outcome of their decision not to challenge or call expert aviation evidence on that point. They cannot get around that. Mr. Alston cannot, on the one hand, rely on the aviation evidence contained in the AVS Solutions report in his evidence to show that there is no reasonable prospect that the airport will not return to airport use, but then ignore the unchallenged evidence of aviation experts that have clearly stated that the ABS Solutions report is fundamentally flawed, and who have given clear reasons as to why that is so. Mr. Alston's position, as with so much of his evidence, is untenable and frankly incredulous. The reality is that in light of the unchallenged expert evidence, the reality is that in light of the unchallenged expert aviation, evidence before this inquiry, no reliance can be placed on the ABIA report. The only expert evidence at this inquiry is that with the right level of investment and the right focus, the airport can be successful, and any decision on these appeals has to proceed on that unchallenged basis. Moreover, it is no answer to say at this inquiry in respect of these appeals that more work is needed to promote the DCO to return the airport to airport use. Whilst that of course is correct, that additional information will be needed to conclusively prove that the DCO should be made. That, it is agreed, is a different test to the one here for these appeals. The test here is simply whether, on the evidence before this inquiry, there is a reasonable prospect, namely a prospect that is not merely frivolous, that the airport will return to airport use. Clearly, in light of the unchallenged evidence, that test is satisfied. A different conclusion in light of the unchallenged evidence cannot reasonably be reached. Moreover, it is also no answer to say that the evidence base for the Thanet local plan, which covered the period to 2011, is out of date, or that policy EC4 is out of date merely because the plan period has passed. Policy EC4 is, as of now in 2017, a saved policy. It cannot simply be out of date because the year 2011 has passed, and in fairness, no witness has suggested that. Moreover, the unchallenged evidence at this inquiry indicates that there remains a strong evidence base for that policy. The explanatory text for policy EC4 recognised that the success of the airport was in large part dependent upon investment being made. Whilst that investment was not made, the plan anticipated that levels of about 1 million passengers per annum and 250,000 tonnes per annum could be achieved. The unchallenged evidence of Mr. Kane and Dr. Dixon clearly demonstrates that with appropriate investment, that passenger levels of about 1 million passengers per annum and freight tonnage of about 250,000 tonnes a year can be realised. In light of this unchallenged evidence, it cannot be said that the evidence base of the local plan no longer holds good. The final point made by Mr. Alston on this matter is that the DCO has not progressed as much as it might. That is totally self-serving. One of the main reasons for the delay to the progress of the DCO is the refusal by the appellants to allow River Oaks professional consultants onto the land to carry out survey work required for the environmental impact assessment. Mr. Alston seemed to think that a legal process had to be gone through for access to be obtained. He did not seem to understand that the invocation of the legal process under Section 53 of the Planning Act 2008 is a last resort, where owners have refused access and where they are forced by law to allow access to take place. He could offer no explanation as to why the appellants had refused to allow access onto the land over a period of a year, and agreed in the absence of any other explanation, it simply appeared that the appellant had been uncooperative and unhelpful. Clearly no reliance can be placed on the lack of progress of the DCO due to the appellant's unhelpful and uncooperative behaviour. In light of the above, it is clear that there is a reasonable prospect of the airport returning to airport use, and that the reasons relied upon by Mr. Alston to suggest otherwise cannot, on any proper or sensible analysis, hold any weight or credence. And therefore, in approaching the matter under Section 38, subsection 6, Policy EC4 of the Thanet Local Plan 2006 attracts substantial weight. The proposals are contrary to that policy, and permission should be refused unless there are material considerations to outweigh policy EC4. And these submissions now turn to the matters that the appellants put forward as material considerations. And just turning then to those matters. The proposed revisions to the draft local plan preferred options dated January 2017 are out for consultation at the time of these submissions. The proposed revisions include a completely new approach to the Manston Airport land. The January 2015 version of policy SP05 had sought to designate the airport as an opportunity area for the purpose of preparing an area action plan, development plan document, which would be required to consider the retention, development and expansion of the airport and aviation operations. Mr. Alston accepted in cross-examination that the January 2015 version of SP05 was consistent with EC4 and was, as he put it, effectively an update. As such, it could have been expected to attract some weight. However, the January 2017 consultation version of policy SP05 seeks to allocate the site for a mixed-use settlement comprising at least 2,500 dwellings, together with employment and leisure floor space. The explanatory text within the consultation document explains the process the Council followed. It says, in order to satisfy the requirements of the NPPF, which states that planning policy should avoid the long-term protection of sites allocated for employment use where there is no reasonable prospect of a site being used for that purpose, the Council commissioned an airport viability study by Avius Solutions. This was to look at whether an airport was a viable option for the site within the planned period to 2031. The report concluded that airport operations at Manston were very unlikely to be financially viable in the longer term, and almost certainly not possible in the period to 2031. Taking on board the conclusions of the airport viability report and given the level of objectively assessed housing need, the Council considers that the best use for this 320 hectare brownfield site is for a mixed-use development primarily focused on residential. Mr. Alston sought to argue that the Council's housing requirements were a factor in its decision to change its policy. However, he accepted in cross-examination that he was not able to say that in the absence of the report from Avius Solutions, that the Council would have allocated the site for mixed use. It is, we suggest, perfectly obvious that the Council's position changed as a result of the conclusions in that report. And for the reason already explained, no weight can be attached to that report at this inquiry. And therefore, applying paragraph 216 of the framework, the 2017 consultation version of SP05 cannot attract any material weight in the decision. It is at the very earliest stage of preparation, having only just been published for consultation, and at the time of these submissions, the consultation period has not yet closed. The framework says that the more advanced the preparation, the greater the weight that may be given. The policy is nowhere near sufficiently advanced that it can attract material weight. It is inevitable that there will be significant unresolved objections to it. River Oak object to the policy. That objection reflects the points made in evidence in respect of these appeals about the Avius Solutions report. Moreover, Dover District Council's officers have recommended an objection to the policy too, and that's noted in the report to members. The future of Manston Airport is a strategic cross-boundary issue that affects East Kent and potentially a wider area. Officers are clearly concerned that the Council did not enter into collaborative dialogue with Dover District Council before the publication of SP05 in its current form. As Mr. Alston accepted, if Dover's officers are correct and there has been a failure to comply with the duty to cooperate, this has the potential to be fatal to the plan as a whole. Paragraph 1.28 of the report says that while River Oak have not yet submitted a DCO to PINS, the scale of the River Oak proposals and River Oak's commitment to making an application clearly represent a strong commercial interest in maintaining and reopening the airport as a going concern. And this would greatly assist with the regeneration of the East Kent economy and contribute to the UK aviation economy by making better use of regional airport capacity. Whereas here, there are significant unresolved objections to draft policy, that reduces the weight that can be afforded to that policy. The third bullet point of paragraph 216 indicates that the greater the degree of consistency of the draft policy with the policies of the framework, the greater the weight that can be given to them. If, as we suggest, the inspector concludes that there is a reasonable prospect of the airport use resuming, then SP05 is contrary to national policy in the framework and the aviation policy framework, and for that reason too it cannot attract material weight. And therefore, for all those reasons, it's plain that Mr. Alston's position was wrong in insisting in cross-examination that SP05 should attract some weight. It cannot sensibly have any material effect on decision-making in this case, given the stage it has reached, the objections to it, and its inconsistency with national policy. It cannot possibly outweigh the application of the policy of protection, policy EC4, and is most certainly not a reason for determining the matter other than in accordance with the development plan. I now turn to the need for employment. The appellant's case is that the buildings are suitable for the proposed uses, and there is a need for suitable employment floor space in the district of the type offered by the appeal schemes. With the exception of Building 4, the buildings are not presently suitable for the proposed uses. The proof of the pudding, of course, is that despite the appellant having promoted a planning application for permission for a change of use since May 2015, there is no evidence of any current market interest in taking those buildings. As Mr. Alston accepted in cross-examination, if there was any real evidence of market demand, the appellant could have led evidence about that, say from an agent, but no such evidence was adduced. You, sir, will have considered the existing facilities within each of the building in assessing their suitability for the proposed use when you inspected them on your site visit. You may have noticed, for example, and I should just correct this, that there are only very limited water closet facilities in 2 of the buildings, which is Building 1 and Building 4, I understand. There are no toilet facilities in the other buildings. Mr. Alston indicated in cross-examination that although at present there is no settled arrangement, as far as he knows in relation to the management of fit-out, he imagined that if someone wished to invest for their own purpose, that would be their decision. Each of the buildings will be considered briefly in turn, but given that a DCO application is imminent, and given the condition of the buildings, and the very limited range of uses for which they might be suitable, it is hardly surprising that there is no evidence of demand for any of them, with the exception of Building 4, which is presently occupied in breach of planning control. Building 1 is an aircraft hangar, the only one at Manston Airport. It is designed for that purpose. It is a very large building with doors that open to allow access by aircraft. As Mr. Alston had to accept in cross-examination, it is in poor condition. It's the view of the Council's Head of Economic Development and Regeneration that there is limited demand for larger units in Thanet, and this is borne out by the fact that as things stand, there is no identified occupier for the building. The planning application in respect of Building 2 was not only for a change of use, but an extension to the building and the creation of a car park. The application was formulated and submitted to meet the specific needs of Instro Precision Limited. That company now has planning permission which will meet its needs for a new manufacturing plant at land at Discovery Park in Sandwich. The company announced that it would be moving to Discovery Park in May 2016. Since then, no other occupier has been identified, and planning permission is still sought to meet the very specific needs of an occupier who is no longer interested in moving there. Building 3 is another large building for which a change of use is sought and for which there is no identified occupier. Its most memorable characteristic, aside from its scale, is its large population of pigeons and the inevitable consequence of their occupation. It is not immediately obvious what that building is suitable for without significant investment, and Mr. Alston accepts that it is in poor condition. The appellant's rather underwhelming employment need case is best described in Mr. Alston's own words in cross-examination, that the demand for buildings like those on the appeal site is limited but not nil. It is in this context that a judgment should be made about the weight to be afforded to the appellant's claim in written evidence that the appeal buildings will be made available to meet the immediate needs of local and other businesses. The overall demand-supply position is straightforward. There is an enormous oversupply of employment land. That was clear even before the Caxton's clip of employment particulars was submitted by the appellant. That demonstrates that there is a wide range of currently available employment land in this area, which is being marketed actively. In addition, although there may well be limited demand for it, there are some existing premises also available and on the market. Plainly recognising that there is considerably more employment land supply in this area than there is demand, the appellant have sought to narrow the parameters for analysis not only to the administrative area of Thanet, but even more narrowly to whether there are premises, rather than land, which are immediately available for occupation, which are comparable in terms of size with the appeal buildings. But in circumstances in which there is very limited demand for large buildings, it is to be expected that they are not constructed speculatively and available for immediate occupation. Where there is market demand, such as for smaller units, as on the Manston Business Park, there are available premises. Mr. Alston tried to suggest that the buildings could be put to BA storage, but again there is absolutely no evidence that there is any demand for that use. It is clear that there is in fact absolutely no need for these buildings to be put over to employment use. It is suggested that Sir Roger Gale may have a point when he suggested that these applications are merely mischievous and are a somewhat feeble attempt to frustrate the airport use. I now turn to the effect of granting planning permission, whether on a temporary or permanent basis, in circumstances in which a development consent order and associated compulsory purchase order are in prospect. Granting planning permission, contrary to Save Policy EC4, in circumstances in which there is a DCO or CPO in prospect, would have the effect of undermining the policy protection of the airport, which seeks to reserve airport land for airport uses, when that protection is clearly needed. It would serve to encourage other speculative applications, requiring a sort of micro-analysis on a case-by-case basis of the prejudice such proposals might cause, when the very purpose of EC4 is to obviate the need for that sort of exercise. Even though Mr. Alston did not seem to appreciate it, the decision in the Stansted Airport Endeavour House was made for the same reason, to prevent the airport from becoming anything other than an airport, and allied to that, ensuring that there is no unnecessary proliferation of additional buildings in the countryside. So, as you are aware, no doubt, the Planning Act introduced a regime for the consideration of applications for projects of national significance. The process from consultation to determination runs on a tightly prescribed timetable and as such deliberately provides a very streamlined procedure, offering the considerable benefit of certainty in terms of timing, and Mr. Alston accepted that. Granting planning permission, whether temporary or permanent, would give rise to the potential for additional occupiers on the land. Use of the buildings as contemplated in the appeal applications cannot coexist with an airport use, contrary to the suggestion of Mr. Alston's written evidence, for the reasons explained in detail in Mrs. Chambry's rebuttal proof of evidence. For years 0 to 2, the appeal buildings will be needed for the storage of expensive equipment, which needs to be on site prior to installation. For example, navigational aid equipment and air traffic control equipment. Storage is also needed for construction plant and equipment to avoid theft. Having secure dry facilities for storage will be essential. Storage is generally important to avoid just-in-time ordering of necessary materials and equipment which can impact upon the construction timetable. Buildings are needed for constructors, welfare facilities, offices and general site setup. From year 2 onwards, the buildings will be used principally for the uses they were once in when the airport was operational. It is no answer to say, as Mr. Alston did, that if the appeal buildings are in use, others can be built if needed. Not only is this a countryside location, and that will be contrary to policy, it would also be poor planning to allow employment use in buildings which will imminently be needed for other more important purposes. It is true that if a DCO is granted, which includes compulsory purchase powers, River Oak will be able to secure vacant possession of the land in order to deliver their nationally significant scheme. However, the introduction of occupiers onto what is presently unoccupied land would greatly increase the complexity of securing vacant possession and would materially reduce certainty and predictability in terms of timing. Introducing occupiers onto the land now has certain inevitable practical implications, all of which compromise future aviation use of the airport. No serious attempt was made by the appellants to grapple with those points. Instead, it seems to have been assumed that compulsory purchase power a complete answer to River Oak's concerns, which of course is not correct. As Mr. Alston acknowledged in cross-examination, when implementing compulsory purchase powers in order to seek vacant possession, those acquiring the land must take account of the circumstances of occupiers and in particular the impact on relocation on their businesses when deciding the timetable for securing possession. In practice, that means delay and potentially possession being taken at different times in relation to different occupiers. Self-evidently, the airport operators would not be able to use the buildings in the meantime. To the extent that physical works are undertaken which are inconsistent with the airport use of the buildings in question, take for example the works proposed to Building 2, cost and delay arise in readying that building for airport use. Finally, having non-airport occupiers on the land makes it much less likely that the airport operators would be able to twin-track an application for an aerodrome licence. Again, the implication is delay and uncertainty. In light of the above, it is absolutely clear that there are no other material considerations that would justify determination not in accordance with the development plan. Finally, sir, in addressing the issues that you identified at the start of the inquiry, we suggest the response is inevitably as follows. Firstly, whether the use of the buildings for non-airport related use is acceptable, having regard to local and national policy, we say the answer is no. Whether the proposals would compromise future aviation use of the airport, we say the answer is yes. Whether the proposals would create additional need for buildings in the countryside were airport operations to resume, clearly the answer is yes. Whether alternative employment land exists elsewhere, clearly the answer is yes. In respect of other matters relating to the CPO and the DCO, clearly the proposals would compromise the timing and certainty of the delivery of the airport following a successful DCO. And so we say that for all those reasons, permission clearly should be refused for these proposals. So unless I can help you with any additional matters, hopefully that covers the points for you.